This is Mark Allenbaugh on behalf of the law offices of Allen Ellis. This is a first in a series of video commentary regarding proposed amendments to the U.S. sentencing guidelines published in January of 2016 by the U.S. Sentencing Commission. These are just proposed amendments by the Commission that the Commission will consider public comment on between now and March 21, 2016. Thereafter, the Commission will vote on these amendments as proposed or any amendments to those amendments that Commission and staff may undertake in response to commentary from the public, at which time they will vote in April on these amendments, and those that do receive majority votes will then be passed on to Congress on May 1, 2016 for consideration. Congress then at that time will have 6 months to veto any of these changes, which they very rarely do. And if Congress does not act to the contrary, then these proposed amendments, or once they are voted on, whatever iteration they may be voted on in May or in April of 2016, those amendments will go into effect on November 1, 2016, in the next iteration of the sentencing guidelines. So last week, the Commission voted on several amendment packages, or at least proposed amendments that they're seeking commentary on right now. As you can see, there's a variety of them. Some miscellaneous technical amendments, compassionate release, which is quite interesting, and we're very happy that the Commission has taken a strong interest in this and is now acting on it. Conditions of probation and supervised release, a very important and often overlooked area with respect to prior amendment years with respect to the guidelines. Animal fighting, there is some proposed amendments to the guideline for that. Child pornography, circuit conflicts, and frankly changes to the guidelines in light of these circuit conflicts, and immigration. Today we're just going to focus on the child pornography circuit conflicts, and specifically the proposed amendments with respect to the child pornography guidelines. This is a very timely issue. The Commission back in 2012 published a very robust and lengthy report to Congress about child pornography offenses and noted some very substantive criticism of the child pornography guidelines. We're going to get into that in a little bit here. It is a bit surprising, though, that it's taken the Commission this long to act on the 2012 report, but nonetheless, we're quite happy that they have acted. We believe that for the most part, these proposed changes are needed ones, although there were a couple of more additional proposed amendments to the guidelines that we're surprised that they didn't act on, or I should say changes to the guidelines. We're surprised that they did not publish proposed amendments regarding. So just real quick, this is from the fourth quarter preliminary data that the Commission published just last month in December 2015, and it just shows you the within guideline sentencing rates by offense category. You can see down here I have highlighted child pornography offenses. There were 1,881 offenses through the fourth quarter of 2015, or 1,881 child pornography sentences, and this includes both production as well as distribution, transportation, and possession. Only 30.8%, which is relatively low when you look through some of the other categories, only 30.8% of those defendants received a within guideline sentence. And again, that is quite low, especially when one looks at the total offense overall, or looking at cases overall. There's a 47.2 compliance rate, or within guideline sentencing rate. But when we look at some of the other major offense categories, you can see it's the lowest out of all the major offense categories. Drug trafficking is at a 35.1% compliance rate, which is also quite low, and that is in part due to some recent and substantive changes to the drug guidelines, as well as some statutory changes that the Obama administration has pushed through. Firearms offenses, though, we can see that that's a very a relatively high compliance rate of 52.7%. If we look at fraud offenses, 40.2%, and then finally immigration is 57.4%, the highest of all the major offense categories. When we look down at child pornography, which is, if we just look at the numbers here, I have to take my word for it, but it is the fifth largest of all offense categories, and again, that only has a 30.8% compliance rate. This table, or this part of the table, reports on downward departures and variances. These first three columns are government-sponsored departures, your 5Ks and your early dispositions and other grounds or other government motions for a downward departure. And then the balance here, these other four categories indicate what would be called either really court-initiated downward departures or variances. And it's this column here that reports on your downward variances. And we could see here, again, child pornography, very high rate of downward variances at 40%. And if you include all the departures and variances, then you're looking at around 44% or higher. And again, looking at overall, the overall downward variance rate is only 17.6%. So this shows you, this was the impetus for the 2012 report to Congress, was the just incredible rate of downward variances for child pornography offenses, far more so than any other major offense category, or at least far more than most other major offense categories, and certainly more than drug trafficking. So with respect to the proposed amendments, this is the actual, this is taken from the actual proposed amendment package that the Commission published. There are basically two proposals that the Commission has made with respect to the child pornography guidelines. Again, the two major child pornography guidelines, 2G 2.1, which pertains to production, which is about 10 to 15% of all child pornography offenses, and then 2G 2.2, which pretty much gets the bulk. There are a few other guidelines that pertain to child pornography offenses, but very rarely are people sentenced under those. The bulk of child pornography offenders do not or have not been charged with a production offense. It's simply possession or distribution, sometimes transportation. But all of those, possession, distribution, transportation, all are sentenced under 2G 2.2, and we will look at that. But just keep in mind that these proposals apply to all the child pornography guidelines. So the first one concerns an overlap, or sometimes what some would call double counting regarding young victims. Now, within 2G 2.2, specifically at 2B, there is a two-level enhancement for a prepubescent minor, and that is given rather frequently. I'll just take a look here. This is from one of the Commission's reports regarding the application frequencies. This is just as of 2014, by the way. We could see here that victims under the age of 12 get a two-level, the defendant will give a two-level enhancement. That's applied a whopping 95.4% of the time. In other words, almost everybody is getting it. So the concern here that the Commission has been looking at is with respect to, excuse me, let me go back one here. With respect to those victims that are under 12, where one gets that enhancement. But then there's also an enhancement at 3A 1.1b for vulnerable victims. The question has been, is that double counting? And there has been a circuit split that has developed on that between effectively the Ninth and the Fourth Circuits. You could read that down here. The way the Commission has come out on this is their proposed change is here. What they're suggesting to do is note the following here. In the the pink highlighted language here. This is what they would propose to add to try to resolve the circuit split. The Ninth Circuit seems to not have a problem giving both, and the Fourth Circuit requires a bit of a higher standard. In other words, that if you're going to get the prepubescent minor enhancement, then if you're going to also get the vulnerable victim enhancement, it can't be age related. In other words, it's not going to be something specifically purely related to age. That's essentially what the commission says here. Ordinarily, you would not get both unless the minor was unusually vulnerable for reasons unrelated to age. But then they note that if the minor's extreme youth and small physical size made the minor especially vulnerable compared to most under the age of 12, and the defendant knew or should have known of this, then you can get both enhancements. Not clear how much this is going to clear up the circuit conflict, frankly. It's just on its face, it's saying you can't get both for reasons related to age, but then you can if the victim is extremely young and small in physical size. So I think the commission is going to need to flesh this out a bit more to have a meaningful substantive change to the guidelines in order to resolve this circuit split. Otherwise, it seems a little vacuous and perhaps just facially contradictory to me. Although I think we all know what the commission is trying to say with extreme youth and small size. There may be an age, some type of age bracket or threshold. That's probably a better word. Just like with respect to the prepubescent minor enhancement, the victim again is 12 or under. They should probably have a threshold at say 3 years or 2 years old or younger or something like that to define exactly what extreme youth is. Some courts might think extreme youth is 6, maybe 7 or 8. Others may not. It's going to lead to inconsistent applications. Although this, in the grand scheme of things, is probably not that much of a concern, because if we look at the application rates for the vulnerable victim adjustment, and this is for everybody, not just those that were child pornography offenders, but for everybody that received the vulnerable victim enhancement last year, there was only 537 out of a total of 73,200 offenders, or less than 1%. So it's certainly a concern, but in practice, it may not have that much of an effect or change. So what will, though, is the other item that the commission is proposing to change or to resolve the circuit conflict on, and that is in regard to distribution offenses. And here the primary issue has been whether or not a scienter or a mens rea requirement is required. In some circuits, if the defendant had possession of or was utilizing peer-to-peer file sharing software, then that defendant pretty much automatically received the distribution enhancement. And the reason why is the way peer-to-peer file sharing software works by default is it opens up the defendant's computer for others with the same software to remotely access his computer to download whatever they wanted, movies, documents, or in a child pornography case, child pornography. And so there the courts have said that was distribution. The Seventh Circuit came out recently, or a few years back, and said, no, that's not, there has to be a scienter requirement there, that the defendant knew that he was distributing. Merely downloading and installing peer-to-peer file sharing software it wasn't enough, certainly on itself, to show that the defendant intentionally or at least knew that he was distributing. And luckily, I think for defendants, and this is the right way for the commission to come down, is the commission has decided to include language to show that a knowing or a scienter requirement is now required. And here is the language that the commission is proposing. The defendant distributed in exchange for any valuable consideration means the defendant agreed to an exchange with another person under which the defendant knowingly distributed to that other person. So the way I read this is there's two components. First of all, there has to have been an agreement to exchange, so almost like a conspiracy, and the defendant knew that he was distributing. So this resolves the circuit conflict, sides with the Seventh Circuit and others that follow the Seventh Circuit, requiring scienter with respect to application of the distribution enhancement. And the distribution enhancement can be anywhere from 2 to 5 levels. And we'll just look at some of the statistics here. And as we'll see, with respect to distribution for things of value, it's not nearly as high as the vulnerable victim enhancement, but there are frequent applications of it. So you have here 18.4% for the 5 level, and the other, and I forgot to highlight this, distribution, basically any other time that these don't apply, you get the 2-level enhancement, and that applies 40.9% of the time. So about 59% of the time, defendants are getting the distribution enhancement. So here, unlike the resolving the vulnerable victim and the prepubescent victim, the interaction between those two enhancements, which doesn't happen very often in practice, and it's more like a theoretical resolution. Here, this is certainly going to have some practical changes, given that over 2/3 of the time, child pornography defendants are receiving a distribution of enhancement anywhere from 2 to 5 levels. So that certainly is a needed resolution, and we're glad to see that the Commission had decided to go that route. Now, one last thing before we leave. These are two areas that we're a little surprised that the Commission has not addressed as of yet, and certainly why they didn't do it now is a little perplexing. Primarily because these are the most low-hanging fruit, crying out for the change. And these are two changes to the guidelines, or two enhancements that even the Department of Justice has said are quite anachronistic. Use of a computer, everybody agrees, that needs to be thrown out the window. It's rather surprising that only 94.9% are receiving this enhancement, given that in this day and age, one cannot conceive of a way to commit a child pornography offense but for using a computer. And again, when this enhancement was first promulgated into the guidelines, it was in the pre-internet era. Or when the internet was just getting started. Most child pornography at the time was distributed through hard copy, through magazines and what have you. So there, in that era, it made sense. It doesn't make sense anymore. Technology has now swamped this. But more importantly, it doesn't make sense why the Commission hasn't addressed this yet. This needs to be taken out of the guidelines completely. And then here, the 600 or more images, or really just the number of images. Generally, you could see here that the majority, over 3/4 of child pornography offenders are getting the maximum enhancement, which is a significant enhancement of 5 levels for having 600 or more images. And as we all know, also in this internet era, the difference between 600 and 6,000 and 600,000 images is nothing with respect to the ability to download. I mean, that's just, you're talking maybe a difference of a minute or two in download time. And even, again, the Department of Justice is on record as saying that this needs to be revamped too, and the Commission has also indicated in its 2012 report that it needs to be revamped as well. There's no time like the present, so it's a little surprising that the Commission hasn't addressed these. That's not to say that they won't consider public comment during this commentary period on what to address, and I would encourage all of the practitioners that are listening to this and reviewing this, consider writing a letter to the Commission before March 21 to support at least elimination of the use of computer, and to have the Commission address as soon as possible the number of images enhancement. So that concludes our brief discussion of the, the child pornography proposed amendments to the guidelines. Again, the commission will vote on these in late March or April or early April, with final publication to the Congress on May 1. And future editions, we will discuss the compassionate release and some of the other changes or proposed changes to the guidelines. Thank you for your time.